students, welcome back to the weekly session of our Polity and IR series where we cover the important articles that had happened in the previous week regarding the polity and the IR discussion. Now in this week we have some articles from the perspective of polity. One is related to fast track court, another is related to the right to peaceful protest and the power with the state to apply reasonable restrictions. Another article is related to the US and Saudi Pact and how it will derail the condition or how it will destabilize the situation in the Middle East further if that is taken forward, and what is US agenda behind the deal. And fourth is the recent attacks by US on the Chabahar Port, where they have highlighted how they have attacked the Chabahar Port and what it means for India, because India has been discussing or developing the Chabahar Port along with Iran as a counter to the Chinese and Pakistan-led Gwadar port development. So we'll cover these four articles primarily in our discussion. The first article is regarding the fast track court. When we talk about fast track court, what do we realize? That fast track court is not a new thing, and recently Prime Minister Modi has talked about establishment of fast track courts for the people who are caught or for the people who are involved in the paper leak. Now there was a nationwide protest that we have witnessed on 20th of July, where people from different parts of the country have assimilated in Delhi near Jantar Mantar, and then they have organized a march towards the parliament demanding resignation of our education minister Dharmendra Pradhan. Now for this, after it has turned into a wide scale protest and similar protest has been seen around the countries, Prime Minister Narendra Modi has come out and has assured the people of India and especially the youth, stating that they will establish fast track court to make sure that the justice is brought at a speedier pace with respect to the people who are caught of the charges of paper leaking. So let us understand what is fast track court first. What is the fast track court precedence? So PM Narendra Modi has urged the states to set up fast track courts to cut the case pendency and speed up justice, especially in sexual violence cases. And they have also said that this mechanism is not new. It has been present in India since very beginning. We will discuss a case also. This case goes by the name Anwar Ali Sarkar case. We will understand what is Anwar Ali Sarkar case and what happened in that particular case. It led to the development of fast track court. Now the question that it arises, that the question that comes out of this fast track court, will the fast track court solve the problem or not? Now, our estimate also highlighted that there are 2.4 lakh cases pending in the fast track court. But the same estimate also highlighted that the fast track court has played an instrumental role in solving some of the crises. Right to speedy trial is a part of Article 21, and fast track court enables the same. So let us understand what is a fast track court. So fast track court are basically the special courts. The one thing that we need to remember is that they are the special court. They are established with the purpose of expediting the speed with which a case progresses. Fast track court is not different, or it is not that they are guided by another principle. They are basically the normal courts, but in the fast track court what happens that they expedite the process by freeing the case from the normal queue process and they are aligned. So if my case is suppose at number 5th position and my case is of importance, that is, it has been labeled under the fast track court, now my case will be pulled out, my case will break the queue, and my case will be heard on a daily basis or on a speedy basis so that the justice can be given to me at a faster pace. This is the whole idea. Rest all of the procedures related to the evidence etc. will be the same like that any of the normal court. So it is not that they have their difference of justice system in the fast track court, it just expedites the process. Rest all of the things will remain exactly the same. So the purpose of establishing fast track court, they are special court established for the purpose of expedition. The priority includes that of the cases related to sexual offences, murder, kidnapping and cases involving women, children and senior citizens. So I have told you before also that a fast track court changes a case place in the line, not the procedure or evidently standard applied to it. It does not change the procedure or the standard applied to it. Now, the second thing that we need to understand from this perspective is that, is there any dedicated law regarding the fast track court? Is there a statutory law regarding the fast track court, or is there a statutory time limit given to the fast track court that in this duration that the fast track court should give its judgment? So as of now, there is no single central legislation mandating the establishment of fast track court. The idea of fast track court came under the Article 14, which is famously known as Anwar Ali Sarkar versus State of West Bengal, in which the fast track court was to be established. And this was done with the principle that we also associate with Article 14, is that the court said that it is allowed to do so and fast track court can be established in order to keep into mind the principle of intelligible differentia. This principle of intelligible differentia was also born in the same case. That is, intelligible differentia means that equality does not mean crude equality or procedural equality. Substantive equality will involve that the people who are in the similar situation should be treated similarly, but the people who might be in unequal situation, they might be treated unequally. And this is what Article 14 talks about in India. And this was reiterated by the Supreme Court in the Anwar Ali Sarkar versus State of West Bengal case. This has the principle of intelligible differentia, from where we can see that a constitutional basis for the establishment of fast track court comes from. Another article that can mandate the establishment of fast track court is Article 21, because Article 21 and Supreme Court has said that speedy justice is a prerequisite for Article 21, or Article 21 will also says that if we understand Article 21, what we will understand also from this principle is that justice delayed is equal to justice getting denied. So there might not be a central legislation for the establishment of fast track court, but we can conclude one thing, that there is a constitutional basis coming from Article 14 and Article 21. And fast track court has been established in India for last 2 decades. Now the next major thing that we need to understand regarding the fast track court is the funding. Who funds the fast track court? It is also important that who will fund these fast track courts, because we have to also see that who will be funding the fast track court. So initially when the fast track court were established, they were funded by the central government. Now this funding pattern has moved to what we call as the state government. Now it has become a prerogative of the state government to fund these things. So fast track courts were originally funded through the central recommendation body and the Nirbhaya fund. Today most of the fast track court run on the state discretion. Some of the PASCO courts run from the central funding. Rest of the fast track courts are run through the state discretion. So the funding has shifted from center to the state government. Earlier it was coming from Nirbhaya fund, now it is coming from the state discretion. And the last thing is that I have already told you that their fast track court does not mean that there will be a time limit that will be forced. There will be no time limit. So it also said that no statute sets a trial deadline. Speed depends upon the offense, government prioritization or a court order. So speed is not determined that in a fast track court will give the judgment in 10 days, 20 days or a month. It will be dependent on the trial procedure only. The only thing is that we are expediting the process. So fast track court is like any other normal court, but for some special cases, they will break the queue, make the cases which are important related to women issues, related to sexual offences, women to the children, etc. And they will try it on a speedier basis rather than following the same legal procedure, so that justice can be delivered easily. So this was our first article regarding the fast track court. Now second article is related again to polity, and this article basically talks about whether staging of a protest under Article 19. So under Article 19 we have a plethora of rights, and 2 of the rights that comes important regarding the recent protest is, one is freedom of speech and expression, whether we can criticize the government or not. One thing is that. Second thing is that can we assemble peacefully without arms? So yes, both these rights are guaranteed by Article 19. But this will just be one interpretation of the law that is written in Article 19. Because when we read Article 19 completely and we look at Article 19 Clause 2 and Article 19 Clause 3, we will realize that there are also some reasonable restrictions. Reasonable restrictions can be posed on the rights available under Article 19(1)(a) and (b). So we will also look at them. So what has happened recently? Let us see. What was the case involving? What did the case entail? So case was talking about that thousands have gathered in Delhi for the Cockroach Janata Party's march towards the parliament, and police basically charged them with lathi, tear gas to hold a line so that they cannot reach the parliament. Parliament is our temple of democracy, so usually such a march should not have been organized in the first place. Why? Because it will create a security risk and state has all the power to stop the same. But that also highlights that what are the rights available to us, we need to also understand that. So the police used section 163 of Bharatiya Nyaya Suraksha Samhita that has now replaced section 144 of the erstwhile CRPC, the Criminal Procedure Code. Now it has been replaced by the section 163 of Bharatiya Nyaya Suraksha Samhita. So now it is a case of, if we can understand that a statutory law is coming and it comes in conflict with what we call as our constitutional guarantee that has been given. But again, I am telling you that constitution itself specifies that the state has the reasonable power of imposing reasonable restriction, and this is done in proportion. So the court has also said that when you will apply reasonable restriction, when you will go for reasonable restriction, this should be done proportionally, not in the sense that is we will restrict the movement only till the point it is required and not use the brute or arbitrary force against anyone. So this is also what court has said. We will see it in the judgment also. So these are the constitutional provisions related to the same. I have already told you freedom of speech and expression and the right to assemble peaceably without arms, which the students were doing. But then you have to again see the limits that are provided in the constitution under Article 19 clause 2 and 19 clause 3, which says that reasonable restrictions can be imposed on the grounds of sovereignty and integrity of India, decency, morality, relations with foreign countries, and that of public order. Particularly, this thing has been used, public order has been used in this case. Now, the next question that comes into mind, where is the protest organized? So, Government of India has identified some of the designated spots. So, there are something called as designated spots in which you are available, you are told to organize the protest, and Government of India has done this in this case also, where they have given the designated spot to the Cockroach Janata Party in what we called as Jantar Mantar. So there, this protest or this what we called as our right of assembling peacefully without arms is not in private spaces, but at the public places which will be designated by the government. Government had allowed Cockroach Janata Party to assimilate at Jantar Mantar. They have given the permission for the same. Without permission, you cannot organize protest. First, you need to seek the permission. The Cockroach Janata Party also demanded permission from the Government of India for organizing this march, but it was categorically denied by the Delhi police, highlighting the security of the state. So this is the one thing. Secondly, one such another area is Azad Maidan area, which is in Mumbai, so where they can organize the protest. So this was the case that it can be done only in designated spots, which is basically the public places, and it does not cover the private places. Gathering outside these sites remains subject to prior permission, and I have told you that the permission was not guaranteed by the government. So if we go by the logic of the government, such a movement or march towards the parliament was itself illegal because they have never granted the permission. So they should have called off this march, knowing that there is a visible risk involved. Government has clearly not given the right. So this where government also appears to be justified in their demand. So now let us see what is the case law telling about. So Mazdoor Kishan Shakti Sangathan has filed a case with Union of India in 2018. And in this, Supreme Court upheld section 144, that is the right to curtail or right to stop the movement. So they have the right to stop this movement and they have used this, and Supreme Court has also upheld this, and it was upheld as an emergency power. But the Supreme Court also said that it cannot become a permanent ban. So the Supreme Court tried to balance. In one place, they are saying that the government has the authority to restrict the movement of the people, and they can use section 144, which is today known as in Bharatiya Nyaya Suraksha Samhita as section 163. So they can stop it. But at the same time, Supreme Court also said that the right to peaceful protest should not be denied, that constitution ideals should also be followed. So it is a mix of both things where the Supreme Court wanted to do this. Okay. Then the next question was that of Amit Sani versus Commissioner of Police. This was related to the Shaheen Bagh protest. And they said, in this case, Supreme Court said that the protest might occur. There is no denial in that the protest might occur. But in this case, and there is another case if you want to know, this was a case regarding the Ramlila Maidan, or famously known popularly as the Baba Ramdev case. All these case laws are related to the right to peaceful protest. And in Azad Maidan case, in what we called as Amit Sahni case, it was told by the Supreme Court clearly that you have the right for peaceful protest, you can assimilate, but it does not mean that you can create a problem for the public order. Normal people, you might have some genuine grievances with the government, but it should not create a problem for the normal people who are moving through that area. So it should not create a public order problem. So again, the Supreme Court upheld the right that has been given to us by the Constitution, but coming with the reasonable restriction of the public order. What do they say? Arising from the Shaheen Bagh protest must occur in identified areas and cannot indefinitely block the public road. It should not create a problem for the public order. This has been told by the Supreme Court in Amit Sahni versus Commissioner of Police case. So what is the conclusion that we can draw from here? What is the conclusion that we can draw from here? That protest is essential for democratic deliberation, but the state retains the legitimate power to balance it against public order and the rights of other citizens. So there are also limitations. If the Constitution gives you right, then there are also limitations for the same. The next article is related to that of US-Saudi Pact, article related to the IR. Now let us understand what has happened. The US and Saudi Arabia have signed a framework agreement, which is commonly known as their 1-2-3 agreement for civil nuclear cooperation, in which the US and Saudi has agreed that they will go for exploration of peaceful use of nuclear energy. Not military grade, but peaceful use of nuclear energy. Let me remind you that the same 1-2-3 agreement that has been signed is the civil nuclear agreement that US at one point of time has also signed with India. This is their 1-2-3 agreement, is their framework agreement for civil nuclear cooperation. This is the same agreement that they have signed with India. This is a civil nuclear cooperation agreement that they have entered into. So what has happened? Let us understand. The United States and Saudi Arabia have signed an agreement described as peaceful cooperation that could lead the Riyadh to kickstart a civilian nuclear program. So this is the basic idea that what this agreement does. Okay, now Saudi Arabia can go for a civilian nuclear program. What is the statutory basis? I have already told you that it is a part of the 1-2-3 agreement, the standard vehicle for US civil nuclear cooperation. Now it will be passed unless it is stopped in a period of 90 days from their parliament, which is known as Congress. If this is not stopped by the Congress in the next 90 days, if Congress does not stop it, this program will go into the working. The same thing, the same framework used for US-India civil nuclear deal of 2008. So it is the same deal that have been used, as I have already told you. Now the problem is, what are the challenges that might arise? The first challenge is that of dual use technology. What does it mean? That the same centrifuges that process the low enriched uranium can also be used for enrichment of what we call as nuclear grade weapons material. What does it mean? In nuclear technology, this though is a part of science, centrifugal movement is used, and centrifuges are used for the enrichment of uranium. When we use the enrichment of uranium to 15 to 20% of the level, it is used for medicinal purpose and for the energy generation. But when the same enrichment goes to the level of 85 to 90%, we can say that we have achieved high enrichment, and the material, the fissile material that is available, can be used for nuclear weapons. This is what is problematic, because the same technology can be used for the purpose of enrichment of nuclear material to the level of weapon grades material. So this is a genuine risk that has been levied. Iran also tells that we are developing the nuclear weapons, or we are developing the nuclear technology for the peaceful purposes. Now, from this logic, Iran will say that when you are allowing Saudi Arabia to go for this thing, how can you put a limitation on us? Already US and Iran are in a conflict. So this can further deteriorate the security situation in this region. granting Saudi Arabia enrichment rights could hand other regional states like Iran ground to justify their own program eroding the non-proliferation regime in the West Asia. So it can create a destabilizing effect for the West Asia. This is the gravest challenge that we face, that it can create a problem for the West Asian stability. This is the problem that we face. Now, what is that? This is a part of broader US-Saudi courtship that we see. US-Saudi engagement already deals with defense, technology and economic cooperation. So US treats Saudi as a reliable partner in this area. Now, US is again relying on Saudi Arabia in this area. They have a strong partnership already. And the Saudi Arabia was responsible, if we can go in history, that dollarization of crude oil or the dollarization of world economy, because the crude oil payment is done usually in dollars, it was a result of a framework agreement between US and Saudi only. So Saudi has been a reliable partner for US. Now US is again granting conditions or basically concessions for the Saudi Arabia because it wants to use Saudi as a counterweight for increasing partnership between Russia and Iran in this region and China and Iran in this region. So US wants to use Saudi as a counterweight to Iran and its partnership with Russia and China in this region. So US is using Saudi as its ally. So this will do what? This will create a problem. Already there are 2-3 players involved which destabilize the region. These players are three. There are 3 poles that are trying to control the whole of West Asia. One is led by Iran. Second is led by Saudi Arabia, which is a US ally. And then third is what we call as Israel. These 3 poles have basically created problems. Then there is a sectarian problem with Iran and Saudi Arabia. Then there is a conflict between Iran and Israel. So this new deal can further complicate the already complicated multipolar powers situation in a multipolar competition situation in the region of West Asia. It can destabilize the West Asian region even more. We have seen the flip-flop regarding the defense, regarding the peace treaty that was signed between US and Iran in the recent time. So this can further create the problem. So this is what has been mentioned. Washington is countering Riyadh partly as a counterweight to expanding Chinese and Russian influence in the Gulf. So this is the problem. Now the next article is also related to the West Asia from the domain of IR, and it is related to the Chabahar Port. The Chabahar Port that India wanted to develop for Iran. Now Iran and India has a civilizational partnership. We all know that from the times of Indus Valley civilization. Both the countries are civilizational states. So civilizational states here means that the modern nation states have emerged much later, but the civilization that these countries have is much older. So the modern boundaries of India might be fixed in 1947, but the concept of India is from since the time of Indus Valley civilization. And from the time of Indus Valley civilization, we have some kind of trade relationship with Iran. Iran is also a civilizational state where we used to trade with the Mesopotamian civilization, which occupies the region of Iraq and Iran. Now let us understand this case where India has entered into an agreement with Iran to develop Chabahar Port. Now India wanted to develop Chabahar Port for Iran for purposing its 2 purposes. One was the purpose to bypass what we called as Pakistan. It was done to bypass what we called as Pakistan because we wanted to help Afghanistan, and Afghanistan is a landlocked country. When we wanted to help Afghanistan, we were doing it through what we called as the Iran, where we have developed Chabahar Port, and we have also developed a network of highway, Zahara-Delaram highway. So we have developed these highways so that we could have supplied goods and necessary equipment or capacity development of Afghanistan post 2003 when the democracy was installed in Afghanistan. Another thing that we wanted to achieve was to counter Pakistan and China's CPEC, China-Pakistan Economic Corridor, to counter the development of Gwadar Port. That they were jointly developing. And third thing is to basically highlight our regional agenda and connectivity and boost our connectivity in this region through what we called as INSTC, International North-South Transport Corridor. So International North-South Transport Corridor would have connected India with Iran, then to Afghanistan, countries of Central Asian region, to the that of Russia, and one of the arm would have gone to the European countries. So this was a broader scheme of idea that was developed between Russia, Iran and India in the year of 2000. So this was India's idea for the development of Chabahar Port. Strategic as well as economic goals were being met. So it was a geopolitical design that India has embraced into. But India, since the very beginning, has faced problem with the development of Chabahar Port, and partly or majoritarily it has been because of the country's relationship with the other countries. It is not because of India that the problem are being faced, but because of Iran's relationship with the US, how it has deteriorated regarding the nuclear program, and the sanction that has been put on Iran has derailed India's developmental partnership with Iran regarding the Chabahar Port. So what has happened that earlier there was sanction, now recently a dramatic image posted by US Secretary of War Peter Hegseth has showed that maritime control tower at Iran's Chabahar Port was decimated following the US strikes. So this was the first time that direct strikes were happening on the Chabahar Port. The strikes landed on a project India has spent years insulating from exactly this kind of disruption. So this was an attack directly where India was involved. What has the Indian Ministry of External Affairs said? Indian Ministry of External Affairs has come out and said that terminal that India operates, that is the Shaheen Beshti terminal, was not damaged in the strikes. And India Ministry of External Affairs also said that the civilian infrastructural projects or the civilian sites should not be targeted as a part of conflict between US and Iran. This is what India has officially communicated after the recent strike. So what are the two terminals that India is associated with? One is that of Shaheen Beshti terminal, which is managed by India, operated by India Ports Global Limited. This is basically under the Indian control which India operates. And another port that India is looking for is that of Shahid Kalantari terminal. Shahid Kalantari terminal, though it is not still under India's control, but India is trying to control the same. Now, this strike is basically creating a problem because India, I have already told you, it wanted to use the Chabahar Port to bypass Pakistan and opening India's entry into Afghanistan, landlocked Afghanistan and Central Asia. For Iran, it is the country's only oceanic port with direct access to the Indian Ocean, sidestepping the congested Strait of Hormuz. So for Iran also it was very helpful because they were able to decrease their dependency on the Strait of Hormuz. And India has continuously allocated the funds. Last was in May 2024 when $120 million for the given. Now India has faced not only the problems of recent strikes on the Chabahar Port, but also of the sanctions that have been given. Now US has put sanction and they have introduced something called as in the past CAATSA, Countering of US Adversaries Act. And for this purpose, US has first given India what we called as a waiver. But this waiver was later withdrawn from India. This waiver was later withdrawn from India. And this is what basically is creating a problem. Because US has given us a waiver in 2018, then withdrew it. Then it again gave it a waiver for us for 6 months, waiver was restored. And now again, this kind of strikes has happened. So if India has been countering the problem, and we have not been able to deliver on the Chabahar Port because of this. At one point of time in the past, Iran also got frustrated and dropped India from the phase 1 of development of Chabahar Port, saying that we will develop the Chabahar Port on our own because of the sanctions that were put on Iran, where India cannot use dollar based for the payment of development of Iran port in the form of Chabahar. So because of the frustration that India cannot deliver and because of India's problem that they cannot supply the US dollars, it created a problem where Iran told that now we drop India from phase 1 of the development of Chabahar Port. This is the problematic line that we have seen. Now with the waiver that have list, India has effectively lost direct operational control over the region, and India is saying that we are dealing with the relevant stakeholders in the region. This problem becomes even more problematic if we see the union budget of this year, where the budget allocation to the Chabahar Port has effectively come down to 0 rupees, which was 400 crore rupees in the last year. So it is signaling that India is because of the sanctions put by US and Iran involved in conflict with US, India is also distancing itself from the strategic partnership that it has entered into Iran regarding the development of Chabahar Port. The Chabahar basically is an anchors in international north-south transport corridor, which I have already told you, which would have connected India with this region. It is also an alternative to China's Gwadar port. So this is also area, and losing the waiver is widely read as tilting the regional balance towards Beijing and Islamabad. So it can boost the partnership between Iran and China. China is not fearful of the sanctions that have been placed on them. China has already entered into a multi-billion dollar, $400 billion of agreement with that of Iran. And it has been told that China is behind supplying the critical defense technologies also to Iran during the recent conflict. So this basically is not a very good situation for India geopolitically, geoeconomically, and strategically, because India has invested years to counter imperial or aggressive Chinese designs in the Indian Ocean region, or to counter what the scholars call as string of pearls. Now, losing Chabahar Port or losing the control over the Chabahar Port will be strategically harmful or detrimental for India. So this is what has happened in the last 1 week regarding the polity and IR section. We'll be coming more of such discussion every week, where we'll discuss what has happened in last 1 week in these two domains. Thank you.